Whereas the Constitution of the United States is the supreme law of our nation, and the Second Amendment to the Constitution states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Whereas the U.S. Supreme Court found in Miranda v. Arizona, 1966, that where rights secured by the Constitution are involved, there can be no rule making or legislation which would abrogate them. Whereas the U.S. Supreme Court in the District of Columbia v. Heller, 2008 decision affirmed that the Second Amendment right to keep and bear arms is not connected in any way to service in a militia. And whereas the United States Supreme Court in United States v. Miller, 1939, states that firearms are part of an ordinary military equipment with use that contribute to the common defense are protected by the Second Amendment. And whereas the 14th Amendment to the Constitution states, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens in the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. And whereas the United States Supreme Court in the McDonald v. Chicago 2010 decision affirmed that a person's Second Amendment rights to keep and bear arms is further secured by the due process and privileges and immunities clauses in the 14th Amendment. The decision also protects the rights closely related to the Second Amendment, namely the right to manufacture, transfer, purchase, and sell firearms, accessories, and ammunition. And whereas the 10th Amendment to the Constitution states, powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. And whereas the United States Supreme Court found in Prince v. United States in the 1997 decision that the federal government cannot compel law enforcement officers of the states to enforce federal laws, as it would increase the power of the federal government far beyond that which the Constitution intends. And whereas the Texas Constitution, Article 1, Section 23, states every citizen shall have the right to keep and bear arms in the lawful defense of himself or the state. And whereas due to dual sovereignty structure of the Constitution, the federal government has no authority to enforce state laws, and states cannot be compelled to enforce federal laws. And whereas the last protectors of the U.S. Constitution are county sheriffs, and we, the people of the United States of America, amen, and our ability to fulfill that role successfully rests in our Second Amendment rights. Therefore, be it resolved, the people of Johnson County, through their duly elected commissioners, court, constables, county judge, and sheriff, hereby declare that Johnson County's support of the Second Amendment in order to preserve for the people of, on, and in Johnson County their rights guaranteed by the Constitution of the United States. And furthermore, we the people of Johnson County, Texas, through this proclamation, hereby declare our rights, our freedom, our liberty, as guaranteed by the Constitution of the United States of America. Thank you.
Amen.